it's a great honor to be able to present this jointly written document by the Finnish specialists. We have this informal, so it's not an official group, but informal group from libraries, archives, and museums, people that are working with copyright, data protection, and other legal issues. And when we, first of all, there is, of course, this data protection regulation from the year 2016, and we also have in Finland this national data protection law that was set up, I think, 2018. And quite immediately after that, we published the first version of this document. I'm now going to present some parts of it. It's a 40-page long document, I think, and in Finnish, but I have picked up some points there. And after these slides, Outi will share us her experiences from the Finnish Literature Society, whose archive is, there is so much personal data in the archive, so they have wide experiences about personal data protection. That's not actually the case in the Music Archive Finland. We are more or less dealing with the copyright issues in our archive. So this document describes recommended practices, processing and protecting of personal data in libraries, archives, and museums. So the document is following the requirements of the EU GDPR, which entered into force in 2019, and this our document was published the same year, but we worked with it, I think, at least a year. So this is not a validated code of conduct under Article 40 of the GDPR, but it's like a recommendation. We cannot like give explicit suggestions that if the case is like this, then you can do like this and this, because that's not the case with data protection. You must always like take the cases individually and try to figure out what's the right way to proceed in a certain type of material. But we have some general guidelines how to help libraries, museums, and archives to plan, develop, and implement personal data protection in their collection management. So I must highlight this, it's a recommendation, not legally binding. And the scope of the document, some words about that. The document focuses on processing and protection of personal data containing cultural heritage and research materials, and also their metadata. And when we process cultural heritage material in libraries, archives, and museums, it usually takes place for the archiving purposes in the public interest. And this is a special situation for the processing of personal data, which is accompanied by certain exceptions of Article 89 in the GDPR. So we have some more rights, for instance, than a commercial company, for instance, for the data processing personal data. And the document concentrates on the data protection issues, not copyright or other possible restrictions such as contracts with the And at this point, I also like to mention that, as Ellen mentioned, actually data protection is not haven't been so much discussed in the European copyright community or European as a whole, or in the scope of the data space for cultural heritage. And I hope that our discussion today will be kind of starting point when discussing data protection in the data space, which is a very important issue. One of the main things in data space, I think, is that the data processing has to follow the data protection regulation. Here are some examples of the guidelines we are giving in this document. For instance, acquisition. The material to be archived containing personal data must be of cultural heritage or research significance in order to be processed in accordance with Article 6 of the GDPR or Article 9 that deals with special categories of personal data. And we also recommend that the donor is, every time material is donated to an archive, library, or museum, the donor is informed about the data protection issues. That is how the organization's processing of personal data related to collections management is necessary for archiving purposes in the public interest. That's the ground of our personal data processing that gives us some exceptions and exemptions how to proceed data. But this processing has to be related to the archiving purposes in the public interest. And there are also, of course, at least in Finland, some other grounds for personal data processing. For instance, if there is some statutory duties that this, for instance, National Library or National Archives carries out. But our recommendation doesn't concentrate on those issues. We also recommend that the cultural heritage organization should have a predefined processes for how to handle requests related to donors' data protection rights. So we have to figure out this in advance to make some predefined processes. And also when we are planning active acquisition of material, the data protection principles related to the use and publication of the material should be considered and recorded in advance. That's one of the main principles that this recommendation is concentrating on. And according to our recommendation, organizing and cataloging are the main means through which cultural heritage organizations implement the general principles of the GDPR and also appropriate safeguards referred to in Article 89. When we organize and catalog material, we have to assess whether the material containing personal data has a permanent value for research or cultural heritage. That's very important. And also identifying the materials containing personal data and determine the conditions for their future use. So these are the main means normally. Careful organization and cataloging. These are the two things that help to find the right balance between data protection and openness. For instance, if there are some material containing these special categories of personal data, that is medical, religious, political, biometric information, their use and availability always require special consideration. We have to keep separate the material that is under GDPR, for instance, and material that we can, for instance, share publicly. If there are in same entity, then we cannot share it at all. But to keep data that has different data protection level separate, that is one of the key issues. And of course, we have to remember that GDPR only applies to data about living individuals. And also, normally or often, the interest and risk related to the protection of privacy and personal data, they weaken over time, while the research and cultural heritage significance often increases over time. And thus, temporary, if we have to restrict the use or availability of the material, temporary restrictions on use are a better way to reconcile the different perspectives than, for instance, destroying the material for data protection purposes. And as I'm already mentioned, restrictions on use should be defined so that they do not apply to a larger part of the material than is necessary. And also metadata is under GDPR, so not only the cultural heritage material, but also the metadata. And thus, personal data that is not important for example, the findability, use, preservation, historical significance, or assessment of reliability of the material, that shouldn't be put there in the metadata, or there has to be very good grounds why to put it there. Otherwise, that metadata has to be restricted for GDPR regulation. So that's also one thing one should consider, not to put too much information there in the metadata, because that might then restrict the availability of the metadata. And when we talk about the processing of personal data, that's a very wide thing. It also includes publishing of the material that contains personal data. And here the starting point is, of course, also that we have to weight the necessary and proportionate the public interest and the protection of personal data. We have to find the right balance. For instance, whether the publication of all metadata is necessary, and also if the phenomenon that the cultural heritage material is related to is more like a general cultural or historical phenomenon or event, is it really then necessary, for instance, to publish the names of the people that are, for instance, in a certain photo, if the names are not relevant to the situation, general situation the photo is all about. And of course, special care must be taken when publishing materials containing these special categories of personal data. especially in those cases, ethical consideration must be made of the risk of potential harm to the individuals in relation to the general benefit to be gained from the publication. So it's always this balance between openness and protection. We published the first version of our recommendation in 2019, and since then there have been, I think, 2 or 3 updates of the recommendation, and the latest update was last fall, when, for instance, a special section containing the use of AI was included. This is a very new thing, so we really do not have gained any experiences yet. But as a general rule, artificial intelligence poses new challenges for data protection because it can quickly process very large amounts of data. And this enables, for example, the efficient accumulation of information about individuals from different sources, and thus create an increasingly detailed and comprehensive profiles. So even though personal data from several different data sets, in that special data set, it doesn't violate with the GDPR. When all this information is combined by AI, then we might have something that violates the data protection regulations. So this is a very important and very difficult aspect to evaluate. But as a general rule, we in this national recommendation, we think that AI Act does not actually limit the application of data protection legislation, but complements it with additional measurements in risk management. But as I mentioned, this last added part, AI, it's very new in our recommendation, and we really haven't had such so much experience about it. But I think I now stop sharing these slides and give the word to Outi, who has been the co-author of this recommendation, also in that very first version, 2019, and also this latest version, which was published last fall. Outi, can you please share some thoughts that I didn't cover, and also your experience as the director of the archive of the Finnish Literature Society?
Thank you. Yes, I would like to share my experiences of how we have used this recommendation for these past 5-6 years. And I myself, I believe that I couldn't have done my work without this recommendation. It is kind of a backbone to everything that we do with data protection, about risk management, about the quality work that we do. And I use this recommendation many ways. For example, if there comes someone new to work at the archive, our archive is quite large. There's 21 of us. And then we also have trainees who are university students who come to work for us as a trainee for 3 months periods. So for everyone in their introductory phase, when they learn how we work as an archive, this is one text that they need to read. And also when we first got the recommendation, I made the whole staff to read this. And I have also ask questions from them so that I know that they have some kind of grip of what is in this text. Usually I ask them that what it is, what it means that the data management in archival work has to be necessary and proportionate. This is kind of my question that I always ask. And if they have a hint of what this is, I know that they have actually read the recommendation. And even if they don't know it by heart, they know that when they need more help, they will read the text or come to me to ask more. And also we work with, for example, the donators with them. And in that kind of interaction, we use this a lot, especially when we get materials from researchers or research groups. We have a lot of, for example, interviews about varied topics. And when a university researcher knows that they are going to have to make new interviews about their research topic, they have the idea that, okay, after the project, they will donate the interviews to us, we will archive them, and then they will stay for hundreds of years in our collection, and other researchers and other users can access them. So they have to make the data protection statement and also inform those that they are going to interview. So usually when they write the first drafts of these papers, they send them to us. And we check them, and then we pinpoint that, okay, this has to be clarified, this is a problem, do not say this way, if you write this in your data protection statement, you are not able to archive, or we are not able to archive the materials. So we are able to do this kind of quality work with these documents as well. And then when there is this kind of university data protection specialist, especially those that are lawyers or those that have recently been informed about the data protection by the lawyers, their first idea is always that you cannot keep any kind of data. Everything has to be destroyed. Everything has to be anonymous. And then when I start the negotiation with the lawyers, I have something to show to them that, okay, we have thought about this. This is based on the EU regulation. This is based on the national law. Look, this is legal. This sounds legal, this text, that we have the right to do this kind of processes. For example, a couple of years ago, we had a problem with one university, with the university lawyer. The researcher was going to interview published authors about their work. So writers who write for a living, they write novels, they have published, and now they are going to be interviewed about their work. And the university lawyer said that you have to anonymize everything. This kind of material cannot be archived. And we just said that, yes, we can. They are published authors. If they agree to be interviewed and if they agree that the material can be archived, there is no problem. Look into this recommendation, into these guidelines. We are going to work according to this. Here are the points in the law that gives us this kind of rule, kind of special points of view that we have to follow, and this way we can do this work. In these recommendations, in any ways, this is looking to the issue of data protection from a very positive point of view, in a kind of way that we can do this. We can keep the culture, the personal data in the cultural heritage material when we do it in accordance to the legislation. We can do this. And also with the special categories, that we can keep also that data. And it also states that we do not need to overreact in a way that if religion or race or sexuality is mentioned, that it would be something very dangerous right away. Because, for example, if you consider everything that has to be with religion and sexuality to this kind of not material that cannot be kept. For example, a picture of a wedding held at a church. That would be illegal to keep as a cultural heritage because it's a church, there's a religion, there is sexuality and gender, at least in some kind of idea in that picture. So it kind of gives us this kind of point of view that you do not need to overreact. You don't have to do all kind of special restrictions to every kind of special data concerning the special categories. But when there is something truly that kind of data that has to be protected more carefully, you have to have operations, processes to do that. For example, we organize ethnographic questionnaires where we invite everyone to answer to our topics. For example, we had a questionnaire about what it is to be young and queer. This kind of material, of course, it needs special restrictions. But when we had questionnaires about gathering mushrooms from forest, if someone wrote in their questionnaire that they had a bad knee and they couldn't go to forest to harvest mushrooms, but then they got the operation to their knee and now they can go there again, no need for special restrictions, even though it considers their health. So we kind of are able to see that not everything is similar when it comes to restricted categories. And this is also things that we have to explain to, for example, to the university lawyers over and over again. But when we have this recommendation, it's way easier and we have this kind of backbone, something to rely on that we are going to do this the same ways. And also the basic is that we do not have to think about them within our organization. I wouldn't have the knowledge to come up with this kind of guidelines and processes, but because in the network, in the legal network that we have, or the network of legal issues in the LAM organizations, there are many people who have knowledge about these issues. We have thought that these together, and this way we have come up with this kind of set of recommendations for all different kind of small and large organizations. And when we say that, okay, we are going to operate in accordance with these recommendations, we are backing one another that, okay, that they are going to do this same way, we are going to do this the same way. We are together kind of rising the quality of the data protection work within our organizations. So I think this is what I wanted to highlight, and I would recommend that you take the our recommendation. It's in Finnish, but artificial intelligence is great tool. Translate it to your own language. If you have some kind of network who could work on and make a similar that is in accordance to your national legislation, I will wholeheartedly give you the permission to kind of borrow whatever you wish from our text and reuse it when writing your own recommendations. Or even if you want to have some kind of help for the work in your own organization, use the material any way you wish, but remember, always check that what the national legislation says, because this recommendation is written in accordance with the Finnish legislation. So thank you.